Okay, the recording has started. We'll call our meeting to order. First thing on the agenda is a roll call. It'll be individuals, so we'll go with Manager Waller.
Yes.
Manager Wynant.
Present.
Manager Bradley.
Here.
Manager Wagaman.
Here.
And Manager Priner here. So the next thing is to set the agenda. Is there anybody like to add or change the agenda today? Any staff?
Staff have no adjustments.
Okay, so we will go, somebody to approve the agenda, please. Need a motion?
I move to approve the agenda.
Hey, Marcy.
I'll second that, Bradley.
We have a motion and a second. Manager Waller.
Yes.
Manager Wynant.
Yes.
Manager Bradley.
Yes.
Manager Wagaman.
Yes.
And Manager Priner, yes. Okay. Approval of the minutes.
Madam Chair, I move that we approve the minutes of September 8th, 2020 workshop. Do you want these separate? Do they do separate? Yes.
We usually do because there might be comments on one or the other.
Okay. Okay. I move the workshop minutes.
Second.
Bradley seconds.
Manager Wagaman.
We have a motion and a second. There'll be a roll call. Manager Waller.
Yes.
Manager Wynant.
Yes.
Manager Bradley.
Yes.
Manager Wagaman.
Yes.
And Manager Priner, yes. September 9th.
Madam Chair, I move the minutes of the September 9th, 2020 regular meeting for approval.
Manager Wagaman, second.
We have a motion and a second. Manager Waller.
Yes.
Manager Wynant.
Yes.
Manager Bradley.
Yes.
Manager Wagaman.
Yes.
And Manager Priner, yes. Okay, next is the consent agenda. Is there anybody who would like to have any explanation on any of the items on the consent agenda?
Madam President, I'd like to talk about item number 19114, proposed wetland bank.
Okay.
Pull that out, or we can talk
Pull
about
that
it, or
out.
whatever.
Yeah, we'll pull that out. Let's go to the rest of it for the consent agenda. I'll need a motion.
President Priner, sorry if I can just jump in here. This is Patrick
sure.
Hughes.
Go
Yeah,
ahead.
I did also have one revision to permit application 19114. I can quick share that here, my screen. Oh, that did it? Yep. So on page 23 of the packet, under section 7, providing clarity to match one of the compliance items. So this would be revised to say that the easement as well as title insurance in favor of the state. And then it would be striking the sentence and for bank credits to be used for replacement within a CWPMP area, the district. So just that one clarification item.
Okay. Well, then, as long as we're on this one, let's go ahead on this one first, and then we'll do the rest of them. Let's consent. Go ahead, John. Then. We need a motion, I think, and then we go back to discussion.
I need a motion. Oh, Madam President, I'll move the consent agendas 20-54, 20-073, or 20-078. And item number 19-114 for discussion.
I'll second that.
You have a motion and a second. Any further discussion on that?
Just
If
that
not-
they, I don't think you said they were cap rocked.
Oh, okay.
Yeah, I moved to cap rock them, yes.
Yeah.
President
Madam Chair,
Pryor,
Okay.
just clarifying procedurally, does the motion include approval of 19114, or was that pulled for discussion?
No, he held it for discussion, I believe. Right, John?
Yes, I want to talk about that a little bit. You want to approve these others or to have the discussion now, Madam
No,
President?
we're going to go on with what we already started here. So we have any further discussion on the cap-rocked items 20-054, 20-073, or 20-078? No further discussion? Okay, we're going to call for a vote. Waller?
Yes.
Wynant?
Yes.
Bradley?
Yes.
Wageman,
Yes.
and Priner, yes. Okay, now we're going to go to discussion on 19-114. Need a motion on that and then a discussion.
Madam President, I'll move 19-114.
For purposes
Or
of
caprock.
caprock, in accordance with the engineer's report.
Yes.
Bradley will second that.
Okay, we have a motion and a second. Now we have discussion. Go ahead, John.
So when I look at this, I wonder if the rules are incomplete here. One of the things this does is it backs up a lot of water, creates a lot of impervious surface. And you can see that by the drainage differences that they talk about over here on item number 5 on page 23 of the packet. And the discharge rates that change. And so I have some questions about this that come to, I think that would need to be looked at. For example, basically what this isn't creating a wetland, even though that's the language used, it's changing the wetland types. And when that, so it's not really a restoration in the sense that it's a restoration of a particular type of wetland. And so I see this as not preserving our flood control. Right now, the basin has an ability to absorb a lot of water. And when you dam up or weir structure or lessen that amount of water to come out of there, then you have a loss of that capacity in order to store that. And the next thing, once you lose that capacity, that creates an impervious surface. So we lose a stormwater storage again with the impervious surface that runs off. If we get larger impervious surfaces, and evaporation plays a role in this. It takes longer times for that to draw down. And so then what are the impacts on the upstream and downstream individuals here? You know, these soil types, when you dam the water up, don't coordinate directly with property lines. So you can have muck soils that are in this basin, and you fill the basin up with water, it'll go across the other person's property line that's either upstream and cause them the same loss of drainage values. And so that's, we don't consider that impact on it. And I wonder if this is really an improvement of property. To me, it's I don't see how it's going to be a greater value increase. And so there's no extra taxes collected off of this. Now, that's one of the things when you develop properties and create impervious surfaces, we put in safeguards in order to control the water going on to the next, hopefully going on to the next property and downstream. And in this case, I don't see how that it changes the tax value. It's wasteland already because it's wetland. That's the lowest grade of taxes. And I don't see any improvement by making it a bigger piece of wetland or a different type of wetland. So, and I'm very concerned about how it impacts all the other people that are in the basin, not just this couple hundred acres that we're talking about. There's a lot of other people that drain into this. And if that loss of outlet may have not only an impact on their soils because the water will seep across the property lines, but also on the future for what they can have for runoff. So I also noticed that there's no map on the map that's on page 24, shows that big red line of where the property's in there. There's all these things on the bottom here. It says private natural waterway, private ditch, public ditch. None of that's shown on here. Yet they were talking about putting weir structures on ditches and changing outlet structures. And that, so we don't have any idea how that impacts the rest of the basin or the many property owners that are around here, small property owners. So I find this, like I said, incomplete as a study as to what's going on here. And because we don't take a look at the impact that this will create both upstream and downstream. And remember, once you create more impervious surface within this couple hundred acres, that means you're going to have a bigger flood runoff, or at least longer flood runoff downstream than you normally would have. And when you change these wetlands and the types from say 1s or 2s to 3, 4s or 5s or 6, 7s and 8s. That's more and more water. Doesn't evaporate, doesn't go up and down, and it's the longer continuous time in there. And so their properties may be devalued also. As I said, I don't see how this is really a benefit or increase in value of property. So that for that reason, I think it's premature to authorize this.
President
Could
Reiner,
Chris
Board of Managers.
respond to
Oh, I'm
that?
sorry.
Go ahead,
Pardon me?
Patrick.
Okay. Sorry, just for some clarification points. I don't see that the project is adding any impervious surface for the definition of the district. This is restoration and rehabilitation of wetlands, like you mentioned. It's not wetland creation. It's not anything new there, which I know that maybe some of the cities would have been opposed to. So this is looking at more of a historic condition. You know, the project has been farmed and ditched and everything. And so some of those ditches are being filled, but then there is excavation also going on site for that material. It's not bringing in new material, those sorts of things. So it is kind of, you know, restoration of maybe historic wetlands. And it's done in conjunction with, you know, state rule and some of the guidance that they have for these sorts of sites. I will also note that our engineer did look at the drainage aspect of it and worked with the applicant's engineer, and the rates leaving the site. It is an increase. I'm sorry, not an increase, a decrease from the existing condition.
So, Madam President.
Go ahead.
So, Patrick, you said the rule of impervious surface under the district's definition doesn't include water surface, eh? So, a lake, for example, is an impervious surface, and when you increase water surface, or then you have a loss of under the district's rule, you don't count that. That's why I say the district's rules are really inadequate here, because impervious surface apparently isn't included with surface water. And when you saturate those soils that are muck soils, what's the impact on the neighboring property owner? And how does that impact his drainage? For example, you're having less drainage go out of here. Well, that means that entire basin, Patrick, has to have, it doesn't have the same amount of drainage as it has before. Remember, drainage was an improvement. And what you're doing is, what this is doing is devaluing or disimproving, removing those improvements. And so you have to demonstrate where there's a value to this, other than just that it's an ecological garden for wildlife botanists.
President Reiner,
Go ahead.
if I might, there were 4 separate items that Manager Waller brought up. Patrick did speak to the storage, and Manager Waller just responded. Yes, the surface water, or a body of water, I think in the engineering world is seen as an impervious surface. There is a disconnect, if you will, in the definitions between what our rule looks at, hard surface like concrete versus water. But in the engineering world, they are modeled the same, I would say. And I'll look to Chris here to chime in. And I'm looking at page 23 and the table where our engineer did, and Patrick referenced this here, so that the surfaces were modeled accordingly, the surface water that would result. And you will see that there is a reduction in the downstream impact in both the 210 and 100-year events. So that tells me that there is storage taking place on the landscape, but I'll stop there and ask Chris to clarify if we're looking at that correctly.
Madam President, yes, Nick is correct on that. The modeling that was provided did indicate a reduction in flow leaving the site, not necessarily a reduction in volume, but a reduction in flow because of the added storage due to various modifications that they're creating on site. And as Nick indicated, though the rule doesn't define open water surface as being impervious, the modeling would effectively model it similar to a pervious surface regardless. One other thing to note is that, and Nick or Patrick can correct me if I'm wrong, but one of the primary aspects of this project is to discontinue the use of the private drainage systems on the property that have been conveying private flow off the property. And the district doesn't regulate or require private drainage to continue to exist on the landscape if it's serving those private interests. It doesn't get involved with that. So it really kind of is a decision of how the landowner is utilizing the drainage on its own property. I mean, similar to if a landowner has a tile line on his property that's draining his egg field and he decides, well, I'm not going to maintain it anymore, that might change the characteristics of flow from his property. And really it's something that is not within the scope of the district's rules or its purview. I would see that similar to this. Again, what does engage the district's rules are items like Rule D for the erosion sediment control, Rule F for the wetland alteration, and then there are a few different culvert crossings where we're engaging under Rule G.
So Madam President, so again, we don't talk about the duration issue here. The rules in the district don't face the duration. This person is going to have the same volume of water coming across. It's just going to take forever for it to get down instead of running off in a spring. And that changes what happens downstream. It also changes upstream. Their water won't move as quickly downstream to this basin and then out. So it's not just what happens on that private property in this little hayfield that's here. There's a lot of drainage within the basin, within that sub-watershed district that comes in there that has to be concerned about. And that's what the major calculation is for the runoff, is what the entire basin area is, not just what this particular 200 acres is. Your turn, Nick.
President Preiner, if I could.
Nick, before you start, could I add something to it you could maybe answer at the same time?
I'll give it
The subsurface water is what I was questioning. Can you throw that in with your answer? What effect the subsurface water, what effect there is to that?
Sure. I'll give that a try, and certainly Patrick can to join in here. So in regards to the surface water and its movement through the system, I'm understanding Manager Waller to express concern about the upstream and downstream condition from the blocking of the private system. Again, I refer to the table that the volume leaving the site is controlled in the 210 and 100-year event. Yes, the duration will be longer, although I would say it's a elementary part of the district's business that we know that storage on the landscape is important, so that the conveyances have capacity to move those waters through the system. I believe as a part of the engineer's work, they do, I'll use how informally, they chase the volume downstream until it enters a body of water sufficient enough that the issue is dissipated, if you will, in the larger scene. And they look for those hot spots, if you will, where it might cause an issue. The downstream point of these drainage systems, these private drainage systems, is a large body of water, not too far off, and there would unlikely, in my opinion, be a change in that short segment of ditch moving through. To Manager Wagaman's question about the groundwater condition, The ditch itself, typically, our engineer has found it isn't a significant reduction in the groundwater condition. There is some lateral effect, but the purpose of ditches is to move surface water off the landscape quickly to allow crops, corn and such, not to drown under the rain event where they typically would in the natural condition prior to the ditching. There was a concern about pointing out on the map where these systems were on page 24. It does show you the parcel, and certainly I can agree that the different call-outs of the legend are not present there, but if you look on page 25, which has a large level of detail, you can see the linear features. They are not individually called out in the legend, but the linear features in the gray black area in the northeast area, the linear features are those private ditches. There are also some ditches in the southwest region in the green blob. Those linear features there are existing private systems. As a routine matter of review of a wetland bank, there is an assessment of upstream condition and whether water would be backed up onto neighboring properties. It would be my belief that that was done here. The other issue that was raised was taxation and changing the value of the property. I don't believe that the district's ever really considered that. It's not a portion of our rules. Rather, I think the district's response is with its regulations and its administration of the State Wetland Conservation Act is for us to respond to a landowner's determination of the best use of their property, and from that, how it may affect the surface waters that you're in charge of. With that, I don't know if Patrick or Chris have something to add about those items, and then maybe we'll turn it back to the board. President Preiner.
Okay, thank you. Any further comments?
I think maybe one thing I can add to that, what Nick was stating, is that if this were to be related to a public drainage system, our review would probably look a bit different on this. It would have a different perspective through how the rights of the public drainage system and the benefiting landowners would be affected by the work. Given that it's not involving a public drainage system, it looks a little bit different. As Nick indicated, we do take a look at some effects that the project may have on landowners, either to the upstream or downstream. But I would have to say that there's a possibility that the project may affect some folks, and I haven't looked at it in great detail. But anytime you have a project that's on a landscape, there's a potential to affect the neighboring landowners, and the district, in doing their in administering its rules, is looking more from a regional perspective of how the project affects regional drainage patterns, regional water management, and if the project does affect some landowners adjacent to it, that really becomes more of a civil matter at that point. And it's important to know that and that's how we review any district project, is that we can't guarantee outcomes for every adjacent landowner related to the project. Our review is really looking toward how it affects things from a regional perspective.
Madam President, could I ask a couple questions?
Go ahead, please.
First of all, I assume from the discussion that none of this water is coming from the ditch itself, our ditch. Is that correct?
We don't have a public drainage system in this area.
Okay. So the private ditches you're talking about, do those extend, because there's no map here, do those extend, that I can see, that do those extend beyond his property? Are those private ditches on property other than this applicant's?
Manager Bradley, no, the private ditches are on the parcels here. Once you get to the north, that gets into Crossways Lake, which is directly north of the applicant's property here.
The headwaters of the public, or the headwaters of the ditch system originate on the parcel, correct, Patrick? And then the discharge point is also a private ditch that goes to Crossways Lake, which is the neighboring property owner.
To Rondout Lake as well, to the east.
Oh, excuse me, yes.
So he's currently putting water into Rondo Lake, and he'll put less water into Rondo Lake, or slower water into Rondo Lake?
Correct.
On the tax issue, John, I would note that if he ever sells credits, we'll get our taxes out of that. But I don't think wetlands I don't think are looked at as a taxing issue. The wetlands are looked at as a public benefit. I don't think Rice Creek wants to say that we're against wetlands.
I'm wondering, and to John's point about the neighbors having some say, is it possible that we need to have a public hearing process in these things? So the neighbors can come forward?
I would certainly support that.
I'm just saying it, maybe that's something we should incorporate at some point.
Madam President, I think that's something we should look at, because it definitely could have an effect on other people. And I think beforehand's a lot easier to deal with than afterwards.
Yeah, we have experience in that.
Yeah.
Uh-huh.
So it wouldn't cost us anything but a little bit of time to send a notice to all the upstream, downstream surrounding properties that we've received a request and we intend to take consideration of this at such and such a date. Your comments are welcome.
So, Madam President, I don't have any objection to that suggestion. I'd support it. But just to continue the conversation with Manager Bradley a little bit about taxes, that's nice to take a look at capital gains. But in this case, these people pay a tax to the Watershed District for drainage. And even though they may not, and I do not know if they were an original benefited area of a public ditch or not, since the Watershed District took over, all of the district is in some public drainage system, someplace. Eventually it gets to that regional point, as it was pointed out by the district lawyers to me some 20 years ago, 25 maybe now. So I would say that they all have an interest in this, because they are paying a tax to the district for stormwater management and drainage. And so that's, and this is a devaluation of that. I realize people think that wetlands have a benefit, but it's a wetland already. But the change here is in the type. And I disagree very strongly with Administrator Toms that a duration isn't important. It is very important, because it changes the type of how long that water is there on the surface, or even below the surface within a foot. It makes a difference on what you can do. And once you get to be a type 3, it's against the rules to touch it. So that's why changing a 1 or a 2 into a 3, it can have a dramatic impact on your properties. And I have personally experienced this. So I understand that. You will remember, Mike, the picture of my cow.
You're more than a wetland. You're a lake.
President Preiner,
Go ahead.
just to note a point, Manager Waller's disagreement with his understanding of my statement. It's not to say it isn't important. It's not represented in our review or our rules, that duration of runout that we're referring to. For all practical purposes, as Mr. Otterness noted, that has been seen historically as something that becomes a civil matter, starts to deal with common water law about where waters have historically run and if they can continue to do so. Yeah, I'll leave it at that.
So, Madam President, not to be argumentative with you, Nick, but my original statement I began was to say that I felt the rules were incomplete, that they don't address the impacts of this particular situation. That's what I'm getting at.
President Reiner.
Can we get staff to comment on the discussion we were having about giving notice to surrounding properties and bringing this, tabling this until we can do that?
Certainly, President Reiner, point of clarification, and then to Manager Bradley's. Staff is shouldered with the rules as written, and so that's what we bring before you is our review against those standards. Breaking from the requirements of those rules and having a public hearing, I would defer to Chuck, counsel, and how we go about that. If that's if we could get some guidance on holding a public hearing on this matter when it's not required in the statute with the
I wasn't
implications.
particularly talking about this one. I was talking about maybe we need to look at that as a change.
Okay.
Go ahead, Chuck, please.
And Madam President, may I just ask Chris one last question? Because I still don't understand one thing about the subsurface water.
Sure.
Okay, Nick mentioned that the ditches, but we are damming some of the ditches up, right? I mean, they are putting weirs in. And I'm just curious I don't know what can be done. It's on his private property, but I am curious what he thinks the effect is to the groundwater around that.
Madam President, Manager Wagaman. So I would have to say that that kind of effect would be difficult to know unless you did a real comprehensive study of the subsurface drainage patterns all around that area. You'd have to get a geologist on board to look at how flow patterns are through the soil. It's something that's pretty complex. I would have to say that anytime that you increase water levels on the property, there can be some carryover, beyond where the wetted area of the pond is for how the water levels are affected in the soils. How far that's going to carry, I really don't know, but it's one of those things that, it really is outside of what our review is, and to require it from a review of an applicant would be something that would be, I think, well, both challenging for us to even review and challenging for any applicant to be able to meet to get to that level of detail. I don't think that it's not likely to carry real far, but it would have to, you would have to do a lot of study to know it definitively.
Madam President, can I comment on the question of whether or not our rules hamstring us at this time? I'm mindful, and I'll share an anecdotal story of my first year as a lawyer when I was arguing that a holder of a liquor license didn't have a property right and therefore no entitlement to due process. And a district court judge in Rochester kindly reminded me, I would think the state would want to give them due process. So that's my view. Adding process that protects the public is not going to be seen as something that we should be slapped on the wrist for. Go ahead, Chuck, follow that one.
I think it would be the recommended policy to ensure that the public is kept fully out of this board's expert decisions. Thank you. No. As I concur, simply on the procedural matter that the district needs to make its decisions within a general timeline of state statute 1599, which you're familiar with. Within that framework, the board can certainly prescribe additional procedures to get as much input from nearby landowners and other interested parties. There's a couple of different options. That in reviewing banking plans, the district is following the state WACA rules as opposed to its own rules, and those have a process for giving notice of applications, which is pretty limited, and it doesn't go out, for example, to adjacent property owners as a matter of course. The district could certainly expand on that and just have a practice of providing notice a little more broadly to those interested parties. And if they show interest, then they can either come to the board's proceedings like anybody else and offer comments, or you could do something a little more formal where you're using the term public hearing. You could do that as well, but you do have certainly discretion to have more opportunity to hear from potentially affected property owners.
Well, when I hear the question or the comment that could be a civil thing, that's always too late. If there's a way for us to prevent this, I think we need to really consider it. I don't know that we can do anything on this one because it's here, but we'd have to take a look at the future.
Well,
President Planner,
Go ahead.
I'd just like to note to the board, and obviously you're having a public hearing today on your rule revision. I guess this could be seen as a self-comment where you may adjust your regulations accordingly for the public outreach, if you will, or hearing that you're speculating may be important for these. You have approved some of these in the past, obviously, without that to date.
Yeah, it's just everyone is very different. So
Madam
that's
Chair?
why. Yes, go ahead.
Oh, just to touch though on note the distinction between the process and the actual substance that is raised here by Manager Waller's comments, which is if a matter is before the board and a question becomes an upstream landowner being concerned that the proposed wetland bank or any activity is going to delay the drainage from the upstream landowner's property, we have traditionally advised caution for the district that you may not want to be in the position of being the ones to decide whether the downgradient property owner has the right to use their land in a particular way, or would affect the rights of the upstream landowner. Those are complicated decisions based on legal standards that involve a lot of judgment that go to judges, and judges take facts and make their best judgment. The district doesn't have the authority typically to make a legal determination, and those types of neighbor disputes can go on and on. So that's a separate question from simply getting a lot of neighbor input.
Okay.
President Feiner, Board of Managers, I just want to make one additional point here. I know it doesn't fully encapsulate what Manager Waller is saying, but on page 24, where you do kind of see that outline of the project area, where it shows these parcels on the eastern side of the site, so that's ultimately where it's going to, outlet out. It's going to go to Rondout Lake. Flowage easements have been obtained over that area with those landowners. I don't recall exactly how that came to be, but I believe it's part of the process and something that Bowser was requiring. So there are easements there to acknowledge that flowage.
Okay, any further comments? We have a motion on the table and a second. Further comments? Okay, we're gonna call it. Oh, go ahead.
No, we had a second, didn't we?
We did have a second. Yeah.
Okay.
So we'll go roll call. Manager Waller.
No.
Manager Winan.
Yes.
Manager Bradley.
Yes.
Manager Wageman,
Yes.
and Manager Priner, yes, because there is no other options right now, but we definitely have to look at it.
Thank
So-
you, Madam President.
You're welcome.
Thank you. I hope we look at this in the future. That's why I voted no on this.
All right,
So,
thank you, Manager Waller. Okay, so we're going to recess our regular meeting and go to a public hearing. And we'll say good morning. I would like to open the public hearing to receive comments on the proposed amendments to the rules of Rice Creek Watershed District. On August 12, 2020, the Board of Managers authorized the distribution of these proposed amendments to public comment. We are presently in the 45-day comment period seeking comment on the proposed amendments. The hearing today is to allow interested members of the public to present comments on the board to the board directly. Watershed districts are required by state law to adopt rules to accomplish the purposes of the Watershed Act. These purposes include, among others, preventing flooding, conserving water for public uses, controlling erosion and siltation of lakes, streams, and wetlands, protecting water quality, and preserving wetlands for flood control, water quality, and other public purposes. The proposed amendments focus mostly on the district's stormwater rule as they apply to public linear projects, wetland buffers, and conveyances. They will be reviewed in a moment by Patrick Hughes, the district permit coordinator. The proposed amendment and the memorandum that explains the proposed changes are available on the district website and at the district office. We will also we have also submitted the proposed amendments to the Minnesota Board of Water and Soil Resources, all cities and public transportation authorities in the watershed, and other interested parties in order to receive their input. The Board of Managers encourages comment today and any further written comment before the end of the comment period, October 9th, 2020. I will now ask Mr. Hughes to offer a further background on this rulemaking action and briefly review the proposed changes. When he finishes his remarks, the floor will be open for public comment. At that time, if you wish to comment, please ask me to recognize you. State your name and address for the record. We ask that you limit your comments to 5 minutes. During public comment, managers are welcome to ask questions of the commenters to clarify the records. I also may ask Mr. Hughes and our engineer to respond to any technical questions raised. I would, however, ask that if a manager then wishes to speak of the merits of the proposed change, this will be reserved for a later time when the board will have the opportunity to discuss the changes. Patrick, would you like to proceed?
Yes, thank you, President Priner. I'll attempt to share my screen here. I think that is the full presentation mode. Can someone confirm?
No, it's not.
It's not.
It's not the full screen yet.
It's currently showing the individual slides on the left.
Yeah.
Okay, let's see.
If I might suggest, if you stop sharing and then maybe start it again under the presentation mode.
Sure. Well, it doesn't seem to want to do that. I apologize.
Aren't you glad we're not a bunch of fifth graders?
I'll start moving around.
Yeah. God bless those teachers.
Well, I guess unfortunately we're gonna have to do it this way. Of course, I tried to do it a different way here, and it's running through a different application on my computer as opposed to the PowerPoint one. I think Nick was going to say something there.
Patrick, just to trying to get, are you trying to hit play at the top there?
Correct. Yes.
Yeah. Okay. Alternatively, if it's important, I guess Chris could, maybe he has it available and could share it if you'd like to try that. Chris, do you have it readily available? Or
yes, yeah, I'm
is
just
that-
bringing it up. I certainly can do that.
Patrick, does that complicate your presentation with notes or anything?
Not at all.
Okay, thank you. Maybe Chris will be successful with that sharing.
Six months into these virtual meetings and we're still learning things.
Okay, are you seeing my presentation now fully, or are you seeing my PowerPoint screen?
We're seeing your
PowerPoint.
PowerPoint screen.
I'll try that again. I must have grabbed the wrong. All right, let's try this here, and now
We still see all this. There we go. Up. That's the presenter's view, I believe.
there. How about this?
Nice.
Beautiful.
There we go.
All right,
Beautiful.
Patrick, let me know when you want me to advance.
Sure. Appreciate it, Chris. Thank you. So Board of Managers, so the technical memorandum from Smith Partners, what we've kind of referred to as the sonar and the proposed rule itself, are available in the packet once again. That is starting on page 46. Rather than go through each individual change, I'll just run through a presentation here, kind of going over more of the notable changes. Chris, if you want to go to the next slide there. So I'll talk about the more substantive changes that we have to the rule, some of the more minor ones that are more for clarity purposes, and then we can go back to the public hearing and board comment and anyone who's on the call who'd like to make that comment. So this PowerPoint is pretty similar to ones that Mr. Otterness has given previously, so I don't expect anything here to be kind of new information to the board. But these are the substantive rule changes here. The water quality treatment standard for public linear projects will be modified to align with the proposed MS4 requirement. This new standard would be 1 inch over new impervious surface or 1/2 inch over new and reconstructed impervious surface, whichever is greater. The threshold would also be increased from 10,000 square feet to 1 acre. And I would like to note that at this time, we don't have an update on the status of the implementation of that MS4 update. But I think Chuck has mentioned before that the comments that the MPCA is working to address at the moment would not have an effect on this public linear standard. The next change here is to provide clarity for the single family residential construction portion of Rule C. There is an existing challenge of knowing when a single family residence also operates a business, and it gets kind of murky in the rule. So the proposal here is to add a 10,000 square foot impervious threshold, similar to other portions of the rule. This would exclude driveways and captures that kind of business aspect of it. There's also a note here at the bottom that this does switch this exemption. A number of exemptions in Rule C are being moved to a new section C12. I want to go to the next slide, Chris. Okay, the floodplain alteration rule currently allows for a one-time fill exemption of 10 cubic yards, the de minimis, which is listed there. Based on Houston Engineering's assessment that we've done here recently, increasing that one-time exemption to 100 cubic yards will have no measurable effect on floodplain elevations at a regional scale. So the proposal here is for Rule E3 to be changed from that 10 cubic yards to 100 cubic yards. And we'd also add an additional sentence there that would allow the exemption to be used for public road authorities on a per project, per floodplain basis. As far as wetlands, the district has received a number of variance requests for the CWPMP buffer requirement. It is a common challenge that applicants are finding in our rule. So the proposed solution here is to revise the language to still maintain that 50-foot average requirement, but to require 25-foot minimum at all points of inflow. This would allow flexibility for applicants to still meet the total buffer requirement, but have some more flexibility if in certain spots it has to be less than 25 feet, 10 feet, in some areas, but to still meet the overall goal of this part of the rule. And the next two slides here kind of highlights that there is some overlap and confusion, I think, between rules G and I for what drainage systems are regulated under which. So for this one specifically here, the proposed change is for Rule G to regulate regional conveyance systems that carry flow from a drainage area of greater than 200 acres and extends across multiple parcels. So this change would eliminate 103E drainage systems from Rule G. Then similarly, Rule I would be updated. This would then relate to the 103E public drainage systems. And as listed here, there's a number of things that we would add. This would include rule triggers for dewatering practices and utility crossings, excuse me. And then some just minor for clarification in the rule, part of that with easements and such. So that's kind of the substantive changes, and then we can kind of go over some of the next changes here, which are a little more minor in nature and providing clarity. So the first bullet there, water management district charges. These are currently collected prior to permit issuance, but this would, put a spot specifically in the rule in Rule B for that requirement. And the second bullet here, as has been previously discussed, this would allow the district to indicate a smaller conditional approval time frame for projects that are after the fact. We're not then giving a full year to submit those compliance items and get the permit issued. This allows us to kind of put a tighter time frame and have that application move forward a little. Have it move forward a little quicker to demonstrate that compliance. This slide is relating to the public drainage system easement. This is a requirement currently of rules C, E, and I. And so this would be an update here for the language to be consistent across all three of those rules and to better align with the right-of-way of the public drainage system. The smaller bullets here at the end, the indented ones, would be a revision to the specific widths that we are looking for with that easement. And the water quality exemption for single-family residential development of 7 lots or fewer that doesn't establish new public roadway or no private roadways serving 3 or more lots does have that exception currently for the water quality treatment. This would be a change to the rule to also include an exception for rate control for those projects. And then we would also be looking at an update to Rule D to E for the rate control tie-in with land disturbance projects specifically. This would be an increase from a 1 acre threshold to 10 acres. And we've found, and the engineers found, that this is more consistent with that definition of kind of mass grading projects where you could be changing the drainage patterns on site. And then other changes is, kind of some things a little more small here, updating definitions, clarity on the curve number and rainfall, distribution usage for kind of that Atlas 14 and the stormwater rule, drawdown periods for infiltration practices, and just some other adjustments as we're finding. Looking again here at the proposed time frame, so we're at the public hearing portion of that time frame, September 23rd. The comment period is open until October 9th. Once that time frame is up, we'll go back and review the comments that have been received. The anticipation would then be to bring that review of the comments to the board at the November 9th workshop, and then subsequently have the rule considered at the November 10th board meeting with that resolution for the rule modification. And then an implementation date of January 1st, 2021. Pretty brief, but you know, as I mentioned before, I don't think this is any change from what the board has previously seen. So then we can kind of turn it back to the board and public hearing for any comments that there are.
Any questions
President?
from the board? Yeah,
Madam President, I have one question if I could.
go ahead.
Page 18 of the rules, 80 of our packet.
Mhm.
We have brackets around greater of and or. And it took me quite a while to try to figure out what was going on there. And I don't know if the brackets come out when you finalize these. For readability, it would make more sense to remove the brackets and say the greater of colon, and then it would be clearer what's going on.
Okay, any further comments from the board? If not, we're going to go to the public. Is there anyone in the public who wish to offer comment today? Anybody online that would like to please come forward, say your name and address?
My name is Rebecca Haug. I am the Water Resources Manager for the City of Blaine.
Okay.
And a couple of my comments are just concerning the change in runoff for new impervious and reconstructed roads, and just curious as to what exemptions will be considered, as well as what the credit will look like for reductions in impervious surface, whether or not that's been determined, and if you can clarify that.
Thank you, Rebecca. Patrick?
I'm sorry, I didn't quite understand the question. I'm sorry, Rebecca.
No problem. It's kind of hard on this Zoom way. What will the credit look like for reductions in impervious surface? That's the first question. And then what exemptions will be considered? Looking for a little more detail and guidance for 1C when we're talking about road reconstruction projects.
Well, I'm sorry, board managers, for the delay there. With the updates here for the public linear portion, I know that language is consistent with what is found in that proposed MS4 update. And I believe that there is mention of an exception in there when it relates to right-of-way challenges. I'm sorry if Chris, if you know what that exception mentions.
I am not sure on that. I would have to dig into that further.
President Preiner,
Go ahead.
if two things. First, a reduction in impervious area would be noted in the calculation of determining the water to be treated, right? Because if you have an acre and the size of the road is reduced in reconstruction, say to 0.75 of an acre, the computation itself is a reduction in the amount of water that needs to be treated. And then to the other matter, Lauren, I'm going to ask if you could, I saw your comment there. Could you share that again? Or Patrick, if you can. Thank you, Lauren.
I'm sorry, what was the question to share? Which comment to share?
You noted, I think you noted for the exemption under the MS4 what that looked like. Could you state that, please, as you understand it currently?
Sure. So this is the current language in the draft MS4 permit, which will now be issued soon. November 16th, 2020 is when the new MS4 permit will be issued. So we'll know more on the final language then. But the current language is for linear projects, the water quality volume must be calculated as the larger of 1 inch times the new impervious surface, or 1/2 inch times the sum of the new and the fully reconstructed impervious surface, where the entire water quality volume cannot be treated within the existing right-of-way. A reasonable attempt to obtain additional right-of-way, easement, or other permission to treat the stormwater during the project planning process must be made. Volume reduction practices must be considered first, as described in item 20.8. Volume reduction practices are not required if the practices cannot be provided cost effectively. If additional right-of-way, easements, or other permission cannot be obtained, owners of construction activity must maximize the treatment of the water quality volume prior to discharge from the MS4.
Wow, that's a lot, isn't it?
It is.
President Preiner, if I could, so pending obviously our rule outcome and obviously what the state determines it will do, there is a good deal of judgment there as to what the applicant is proposing to do and how they evaluate their site for the availability of BMPs. And so to be released of the obligation, our engineer will have to exercise that judgment and communicate the sideboards in weighing those, that exploration, is there right of way to be had? Is it feasible in that location? What other obstacles may exist, such as utilities and that sort of thing? I believe that's the matter that Rebecca is asking for clarity on. I'm understanding that our position is to align as best possible with the MS4, which remains to be seen, but is close at hand.
Is our goal. Rebecca, does that help at all? Or?
That does help. It's just challenging, as most of you know, with these reconstruction projects to make it work. And the city's concern is always when they say whether it's financially feasible or not, and whose judgment is that for financial feasibility. And I understand Rice Creek is working with MPCA rules. These comments have been provided to the MPCA as well. It just puts communities that are doing a lot of road reconstruction projects in a bit of a challenging time to try and meet the requirements.
Madam President?
Go ahead.
Rebecca, would you tell me how would you like the rule read, to read? How would you, what do you think would be helpful to your city?
That's a good question, and I would have to think about that a little bit more as to how I would like to have that read or written. Something that I'd be interested in working with the Rice Creek staff on how to make this work.
Madam President, so Rebecca, I can assume that, is it safe for me to assume that you'll make a written comment and work with the staff before the deadline of October the 9th?
That is a safe assumption.
Thank you. Thank you, Madam President.
Anything else, Rebecca?
No, thank you very much for this opportunity to speak.
Thank you.
President Preiner.
Go ahead.
If I could ask Rebecca before she departs, Rebecca, I understood within your comment to be the city seeking certainty. So in developing a project and what those likely costs and obligations would be. So we will see what MS4 is, but if the district develops either within the rule or as separate guidance, the sideboards as to what, how we're exercising the judgment that would be present, would that be helpful? In other words, if there's, the cost or the presence of utilities and these types of things in somewhat of a structure as to how we're exercising that judgment to give you certainty. Is that what the city is seeking?
Yes, that would be very helpful to have that information.
Thank you.
Thank you, Rebecca. Is there
Madam
anybody
President?
else? Pardon me?
Madam President, one more thing I might
Go
add
ahead.
there to note also to Rebecca here, that might be at least partially addressing her concern is that if she looks at our new proposed rule under Rule C6E, at the bottom of that paragraph talks about how stormwater runoff from new and reconstructed impervious surface is to be treated. And we added a clause at the end of that that's now new to the rule that says, except that for a public linear project, water quality treatment volume for reconstructed impervious surface, if required under subsection 2C, must be provided only to the extent feasible. So we basically added an additional out that is in alignment with the MS4 requirements. If there is water, if it's a reconstructed impervious surface, we provide that out if it's just simply not feasible to provide BMPs within the right of way.
Thank you. That's very helpful. I must have missed that when I was reading through the rule revision. Thank you.
Okay, is there anybody else from the public that'd like to make comment today? Anybody else? Anybody else? Okay, so hearing none, we're going to close our public hearing. And I just want to make the statement now that the Board of Managers has provided that the record will remain open until October 9th, 2020 for the district to receive written comments on the proposed rule amendments. Anyone who wishes to submit comments that you have just offered or in written form or other written comments, please send them by mail or email to Mr. Hughes' attention. Mr. Hughes' contact information as well as the rule documents can be obtained in visiting the district website at www.ricecreek.org. The Board of Managers will carefully consider all the comments that have been offered today and all comments received in writing. On the basis of comments and our own further judgment, we will consider whether and how the proposed revisions should be modified before they are adopted. Thank you for your interest and joining us today. Okay, so we'll go back. Oh,
Madam President,
go ahead.
just for clarification, in our previous item on the agenda on the permits, the discussion, Nick made the point of it being self-examination, and I assume that Nick will continue that discussion without having to be in his review coming up before the 9th. Am I correct there?
Nick, is that your understanding or?
I'm sorry, I'm not understanding the comment, Manager Waller.
Well, you said that our discussion about the rules and changes was a self-examination or self-something. And so I'm hoping that conversation that we've had in the agenda item for the permits would be considered between now and the 9th.
Yes.
And in the future after the 9th also, you know, I mean, I'm with President Preiner here. I think something needs to be done about that. So.
Yeah. President Preiner, Manager Waller, I'm understanding you to reference the comments or the discussion regarding wetland banks and what I understood to be a consensus position of the board that we might include some sort of additional process that would involve neighboring properties. And we can include that comment, a self-comment, if you will, where we would try and augment the rules accordingly.
Thank you, Madam President. Thank you, Nick.
Madam President, regarding those concerns that were placed during that previous permit discussion, how they relate to the rule, maybe it might be helpful to have some clarity from the board on their concerns related specifically to those wetland banking issues. If the concern is specifically regarding increases in water elevation or impoundment of water, ponding of water on a property that previously didn't exist there, because that's something that exists on a number of permits that are outside of wetland banking projects. And I guess maybe some clarity for staff might be helpful on what the concern might be. Is it the kind of the acreage of ponded water that provides the concern, or just the nature inherent to wetland banking projects, the idea that you're removing previously drained areas and now restoring water into those areas?
Rebecca Haug.
Is now
President.
exiting.
Go ahead.
President Preiner, Chris, as a note here, I understood the board to try to increase the public process whereby the neighbor could bring their concern, which may or may not be along the lines of what you shared. And if a landowner did bring such a concern, I think initially staff would look for the applicant to respond to that or enter into a dialogue with the neighbor outside of changing our rules to try and encompass all this. And maybe that's the way you presented your question to the board. I believe we might be in alignment on that. So I'll stop there, and President Preiner, I don't know if Chuck wanted to say something about that or.
Chuck, anything?
Well, I would say, my understanding would be, the option would be to notify potentially interested landowners, and they would raise any concern that they would have. It wouldn't just be limited to potential increase in duration of flow across their property. I guess a question would be, is the board's interest in this additional notice limited to bank applications or a broader range of WACA applications? That's the only area where it seems to me a bit more definition of the board's preference would be useful.
Well, I'm thinking of the banks, because it'd be pretty hard to do, just bring a public hearing or public notice to everybody in every project. Banks are a larger area, hundreds of acres usually. My concern is how far, if somebody comes in and they're the neighbor and they have a complaint, and there's no way to know for sure without extraordinary expenses of finding out how to address that. So I think we have to be really careful as to what we would require. I don't know if you can follow me on this, but it could become just a neighbor thing, like you go back to civil. But at some point we have to be able to make a judgment and move on with these permits. So I guess that's kind of where I'm going with the whole thing. How much do we ask them to prove? And, because everybody will say they're backing up water, and everybody will say they aren't getting enough water. So, and nobody knows the truth unless they've done the engineering. So that's the questions I have about it.
And Madam President, I'm kind of with, this is Manager Wegman. I'm with you on the size of the land banks are usually fairly large. And so I agree with you that is one that could be looked at. If we look at them all, we'll never get anything done. Because the cost of all the engineering on all that would be exorbitant. I don't know how you would even do it. But the land banks seem like something that it would be worthwhile because of the size of them.
I don't know. Does that answer the questions? Or a little bit? Or give you the questions?
Would we be able, and I thought we could, to address these issues one by one as they arise in unique circumstance? My concern on this last one is partly because we didn't have the private ditches shown on the map that we were provided. I understand they were shown on the other one. It was hard for me to see. And the concern was, were those private ditches serving other people besides that one? I kind of see it as a case by case. We don't get that many. And if we had concerns that we didn't know enough, then we would approach the neighbors. But rather than uniformly every time we do this.
Is that something available, Chuck, where you could, when you look at the permit application, we could say, well, that's going to affect a lot of people, we think, should we talk to the neighbors? Or I assume it has to be consistent with every application.
Well, Madam Chair, board members, as a purely legal matter, the district can define the efforts it's going to make to go beyond what the WACA rules require. And it seems you could use judgment and do that in particular cases. I think it would be more of an administration issue than a legal issue to leave it to a case-by-case situation. I'm guessing, that Nick probably would simply like to have a standard policy that would be followed.
My standard policy that Nick would follow would be that when an application comes in and there's reasonable basis to be concerned that it could have adverse impact on neighbors, that staff will reach out to find out from those neighbors if they have concerns. We've had other cases where we've had neighbors come in and specifically waive any concerns. I mean, this would not be our first time we've done that.
But how would we determine that, which ones are which? I mean, we probably all would have 5 different.
I was relying on staff to be and our engineer to understand what's a risky project for neighbors.
President Briner?
Go ahead.
I think from a staff perspective, we would look to have a unified, I'll just say, noticing of neighbors. Certainly before that discussion with the board or consideration of the permit, we would try and work out any issues and have that select group of individuals, their questions answered. I think from there, we would move into the board format where those individuals could come forward and say they remain concerned or they're not, and say whatever they like about the project. And then you could, we'd probably look to have the applicant present as well as our engineer and legal consultant to chime in on the responses, and the board can weigh that in its decision.
So do you think we could do it as an informational meeting and not a public hearing? Where we could just invite them to an informational meeting so that they're aware of the project? Or is that not going to accomplish anything?
Well, I think it would be best, the informational meeting, I was suggesting at the staff level, to define the radius, if you will, and we enter into the landowners with some sort of dialogue. But if there are concerns, it's best that those are on the record and that the board is considering them when we include that in our rules. We are adding a fair amount of process here that doesn't currently exist under the statute, but you are obviously trying to be vigilant about what the neighborhood, if you will, might be concerned about.
Manager Waller,
Madam,
is that what you were thinking?
Yeah, well, Madam President, when you issue a permit, that's authority to proceed. And if you don't know what the impact of that's going to be on those other folks, because soils go across, soil types, for example, don't respect boundary lines, then you say, well, this is just a civil matter, as you pointed out much earlier, then it's way too late to solve the problem. And so that's the comments I have. Okay. I think this is a longer term working thing. I don't see that it can all be done by the 9th. But I want to make sure that we have this in our mind, because rules are evolutionary. They're constantly changing.
I don't know if we should use the 9th as a deadline and let this
go.
No,
I wasn't suggesting that, Madam President. I just hope that we start to look at this, because and on a larger level, not just the simple acreage is there. This map on 25 shows that soil types that are on the property line are also on the other side. So what's going to stop that water on the property line from building up under the other fellows? And the other property owners, their property is going to be impacted here, and they're unaware of that. And it also devalues their property. because it's no longer improved, even though they use somebody else's, dump the water on the neighbor to use the neighbor's private ditches. All right, well, that's enough out of me for now.
But, Madam President, I did have one thing on that. This is Manager Wagaman. Chris said that they were looking at it on a regional level. Because I agree with Manager Waller on that. But can Chris give some kind of an idea how extensive engineering they have to do to look at it on a more localized level like that? Apparently we're not doing that now. I'm curious how.
I don't know, Manager
cumbersome that
Wegman.
is.
I don't know if we should continue this conversation till a later date when we can have more meat and everybody has time to think about it. It's really not part of our agenda. So
Okay,
anything,
that's
yeah,
fine.
okay, if you
I'm
don't mind.
happy to bring it to a workshop.
Yeah,
That's
we'll
fine.
bring it and have more discussion at a later time.
President-
Anything
Okay.
else? Go ahead.
President Preiner, I'm happy to put it on for a future workshop agenda. Just for clarity for the discussion here, it's not that the district doesn't review. It does, and it does look for those adverse impacts.
Okay.
Here it seems the board's discussion is that it would like to entertain maybe greater examination of these types of issues. We have had some previous discussion about that, but the concern continues. And I noted that Chuck did have his hand up. I don't know if there's an issue he'd like to comment on. Thank you. I'll add it to the list.
Okay. Chuck, anything more?
No, Madam Chair, in accordance with your indication that you'd like to move on, I took my hand down. We can address it later.
Okay, let's put it all into one package and have a workshop. Okay, with that, I think we still have open mic. Is there anybody in the audience that'd like to speak open mic? Anybody? Hearing now, we're going to go to items requiring board action. Consider the proposal, selection, and contract for new website design. Beth? Beth here? Hello,
Sorry,
Beth.
I'm here. I'm
All
here.
right.
My second computer screen went to sleep and it's not wanting to wake up. So I'm going to, I was trying. Well, okay. Well, I'm going to kind of fly blind a little bit then. In your packet, you have a memo. It kind of just restate some of the steps that we've taken to get to this point with developing a new website. At an earlier workshop at the beginning of September, we reviewed the proposal from Oxygen Consulting, and this board directed staff to move forward with that proposal. What you have before you is the memo and potential motions to enter into a contract with Oxygen Consulting, Inc. to develop a new website for Rice Creek Watershed District.
Madam Chair, this is Manager Wynett. I move to approve entering into contract with Oxygen Consulting, Inc. for the creation of the RCWD website with a total cost of $55,000. Authorizing the district administrator to execute the document.
This is Manager Wagaman. I would second that.
Okay, we have a motion and a second. Any further discussion on that? No further discussion. We'll move forward with a roll call. Manager Waller.
Yes.
Manager Wynett.
Yes.
Manager Bradley.
Yes.
Manager Wagaman.
Yes.
And Manager Preiner, yes. Okay.
Madam President, in addition to that, I move to authorize the district administrator to approve additional services for the purpose of providing additional content support to staff up to the total aggregated amount not to exceed $5,000.
Okay.
I guess did Manager Wagaman, I'll second that again.
Okay, we have a motion and a second. Any further discussion? Any discussion? Seeing none, it'll be a roll call. Manager Waller.
Yes.
Manager Wynett.
Yes.
Manager Bradley,
Yes.
Manager Wageman,
Yes.
and Manager Priner. Yes, so we move on. Thank you, Beth, for all the hard work.
Thank you all. We will get this going and see the fruits of our labor soon.
Good. Okay, next thing is Lauren, I believe.
Thank you, President Priner, Board of Managers. For your consideration today is a draft response letter to the entities with existing water quality volume obligations. This draft letter reflects our understanding of the board's overall consensus position from the September 8th workshop. And there's a proposed motion on page 136 in your packets.
Okay, we'll go for a motion first here.
Madam Chair, this is Manager Wynett. I would move to define the board's position on the water quality volume obligations as stated in the draft letter and authorize the district administrator to sign and send the letter to the entities as reflected in our board packet, page 137 and 138.
Need a second?
Bradley will second.
Okay, good.
Okay, we have a second. Motion and a second. Any discussion?
Madam President, I will support this motion to distribute the letter, but I do not agree with the contents of it.
Okay, any suggestions?
No suggestions. We had the discussion at the workshop and reached a consensus. I just wanted to be on the record that it was a majority consensus.
Okay, thank you.
Madam
Anybody
President,
else?
I do have two suggestions if I could. On
Please
page 2, the first bullet, the second sentence says, as a matter of equity, it's reasonable to ask Centerville, Circle Pines, and Matamidi to make every effort to fulfill their obligations as well. To make every effort, I'm always happier when we say make every reasonable effort or make reasonable efforts.
Good.
I agree with that.
Okay.
That makes sense.
And then the third bullet, the 3 requesting cities have not identified any particular advantage to simply continuing. I would just remove the word simply to continuing. I don't know how simple it is or not, so.
Good.
I would accept those as a friendly amendment.
Okay. Mike was the second, right?
Yep, that was it.
Okay, so you agree on the friendly amendments?
Yep.
Any other comments? If not, we will proceed with the vote. Manager Waller,
Yes.
Manager Wynant,
Yes.
Manager Bradley,
Yes.
Manager Wageman,
Yes.
and Manager Priner, yes. Okay, we're down
Thank
to
you.
task order. Thank you.
Yes, President Priner, Board of Managers, the next item is on page 139 of your packet. This is a task order 20-13 on page 140. This is in regards to the district's boundary. The district does manage its boundary. You're currently working in Anoka County. Here is a task order to proceed with Ramsey, Hennepin County, and then the portion of Anoka County, which is in the little
Up by
the
Broadway.
upside down horseshoe area of the district there. This will provide the technical information for the district to facilitate discussions with its neighboring water management organizations, and then in the future take on the petitioning of the Board of Water and Soil Resources to adjust your boundary. It's for $35,000. It does result in a couple of technical memorandums and also some GIS viewer information that we would use. And of course, to move into the recommended legal boundary petition process. With that, there is a proposed motion on page 139 of the packet.
Let's have a motion.
Madam President, I'll move to authorize President Priner to sign Houston Engineering Incorporated Task Order 2020-013, Ramsey County Hydrologic and Legal Boundary Review.
I would second that. Manager Wynick?
Okay, we have a motion and a second. Any further discussion? Seeing none, we'll call for the vote. Caller?
Yes.
Manager Wynick?
Yes.
Manager Bradley?
Yes.
Manager Wageman?
Yes.
And Manager Priner, yes. Move on. Okay, go ahead.
President Priner, Board of Managers, next item is on page 145 and the following page 146 and 147. This is a additional services request for task order 19.5. This is for the scope of services on the JD3 repair project. It has to do with construction management. Construction management on site is a little bit of a crystal ball. You're never quite sure how much landowner engagement and such you'll have. Here we're running close to the under the task order, and so Houston is looking for some additional funds, $5,500 to finish out the project. Chris and I have discussed how we proceed with these in the future as an aside here, and we'll do our best to maybe have this written within them, some contingency authorization to the administrator or the board president when these types of situations occur. With that, there is a proposed motion on page 145 of the packet.
Okay, motion, please.
Madam President, I move to authorize President Priner to sign Houston Engineering Inc.'s additional service request for task order 2019-005, Anoka, Washington Judicial Ditch 3 Main Trunk and Branch 3 Repair, Design, and Construction.
I'll second that. This is Manager Wynick.
Okay, thank you. So we have a motion and a second. Any further discussion?
Madam President,
Go ahead.
I mentioned that since our last board meeting, I've received a couple of telephone calls, communications from folks that live on the project, and it's been very complimentary. Very, it's you know, it's not uncommon to have a negative telephone calls, but they have a couple that are positive, and communications are positive. And one of those chaps was president of one of the homeowners associations, one of the very active homeowners associations. It's very good.
Very, very good. It's nice to hear. Thank you, John. Any other
Very nice
comments?
to hear. I have a question. Is this additional management due to the fact that we're one staff short?
Madam
President
President.
Priner, Manager Wynick, I would say no, it is not. As a part of the task order, Houston Engineering is managing the construction on site. As you might imagine, the big machinery and efforts do draw attention from landowners concerned about what is happening, their property, the trees in the vicinity, so on and so forth. And so that dialogue and Houston management of the situation takes a fair amount of time with that, reporting back to the project manager at the office of Houston Engineering. Chris, did you have something else to add there?
Yes, just to further elaborate on that. So when we come up with a task order proposal for any project involving construction management, we do that and go into it with the understanding that, as Nick alluded to earlier, it's a little bit of a guess as to how much effort it's going to take because of the whims of the construction contract regarding how long the contractor's out there working, how much engagement you have with the public. Those are two of the biggest factors. In this case, the contractor is moving along. We anticipate that they're going to come in pretty close to what we anticipated for the the number of hours in their construction management, although we did include in here another $1,500. We think they might run a little bit over on that. The bigger issue on this one was the landowner engagement. This one had more landowner engagement than any of the other projects we've done to date. And you know, we've had a lot of landowner engagement on some of our other projects, but this one in particular, with the number of homes and the concerns about tree issues, it was substantially more on this one, and that's kind of the primary driver for this task order, or I should say this additional services request.
Thank you.
Any other questions? We'll call for a vote. Manager Waller?
Yes.
Manager Winant?
Yes.
Manager Bradley?
Yes.
Manager Wageman?
Yes.
And Manager Priner, yes. Motion passes. Okay, check register.
Madam President, I move to approve the check register dated September 23rd, 2020 in the amount of $393,613.91, prepared by Redpath and Company.
Second.
We have a motion and a second from Manager Waller. Any further discussion? Not, we'll call for the vote. Manager Waller?
Yes.
Manager Winant?
Yes.
Manager Bradley?
Yes.
Manager Wageman?
Yes.
And Manager Priner, yes. Motion passes. Okay, any questions on the staff reports?
Madam President, this is Marcy. I see, Lauren, that you participated in Washington County Drainage and Agriculture Land Use Tour with Manager Waller and Nick. I guess the question is, was that an in-person tour? That'd be one thing. Secondly, does this happen in these kind of tours in other counties also, whether or something else with the soil and water districts? And I'd be very interested in any on-the-ground tours that occur, just to familiarize myself with what's going on the land. So that's my question.
Sure, President Priner, Board of Managers, Manager Winant. It was an in-person tour. We were wearing masks and socially distanced. And it was initiated by Manager Waller's request. And I'm not sure, maybe Nick can speak to the other counties, tours of other counties. Not sure about the answer to that question.
Yes, President Priner,
Yep.
Manager Winant, Board of Managers, staff is always open to hear what any particular manager has an interest in. If there's something on the landscape you would think would benefit by a shared meeting, we're happy to look at those. This was something Manager Waller wanted to share with Lauren specifically and myself. As a thought, this was rather informal, and I don't know that I've seen them in other areas, but certainly that's possible. Obviously, as more managers participate, we run into needing to notice, for the quorum present and that sort of thing.
Okay.
I think that addresses it, but if there's another question, I'm happy to answer.
Well, it just appeared to me like there might have been it was the Soil and Water District or some other organization, but basically
Madam President?
Yes, John?
So, first of all, we all went in separate cars. You forgot that,
Yeah.
Lauren.
I mean, that,
But to get out of it, it was initiated indirectly by the Soil and Water Conservation District, because the Soil and Water Conservation District in Washington County commented on the plan that they wanted more dollars worked on small acreage areas. And so this one, JD2 happens to have the largest agricultural acreage in there, and so we started to look there. And so that's why I asked them to come out, because in addition, at this time, Lauren has her survey out. And I think she's getting a pretty good, some response from Washington County. I don't know actually how much, but that's the purpose of it. And this is so it encompasses quite an area there. But you're welcome to go on a tour with me. I have my truck back now, and I took Manager Bradley when he first came on the board. We took a tour of the area up where we live. I had to tour with other persons that are on the advisory committee over the years. I've had tours with other managers from Ramsey County over the years. We used to go on a tour years ago, decades and decades. We'd rent a bus and go on an annual tour of the whole district.
I know COVID is really clamping down on all of this, but my experience is there was a longtime planning and zoning commissioner from Renville County, and his advice to me is you don't make land use decisions until you've done some personal recognizance. So
good information. Yep.
I'm trying to do that as much as possible, and I certainly don't want to miss if there's an organized tour. So
but I have a strong support for that statement from the man from Renville County that you've given.
yeah.
I will add that it was very useful to see in person what the landscape looked like compared to what we look at on the map level through the district's permitting maps. It was useful to see how that compares and to see what it looks like in person. What are we actually looking at when we look at the maps of the GD2 area?
I think that's very, very good and informational. Okay, anything else on the staff reports? Seeing none, we'll go to the October calendar. Any questions on the October calendar? Pretty simple.
Yep.
All right.
Pretty good.
Oh, go ahead.
Nope.
You're good?
Yep.
Okay, administrator updates. Nick?
Yes, President Priner, Board of Manager, I do have a couple. Probably good to note to the group, early on before the meeting started, I noted mail delivery being slow. I think some of you experienced that. We're well aware of it, and we'll give it maybe one more try here. Otherwise, we'll move to a defined delivery through a private firm such as UPS, FedEx, or something similar. So I'll note that we are shopping our life insurance benefit through North Risk Partners. We contract with them to make sure we're using the public's and staff's dollar as effectively as possible, getting the most for our money. I'll note here that we have our Green Corps member has started with us. You'll remember that's does not cost the district. It's an 11-month term, and that individual is Ben Rowland. Ben, I believe you're on the line if you'd like to introduce yourself to the Board of Managers. If you're there. As we're waiting, Ben is from Washington State. He attended McAllister College here in St. Paul. That's why he's in the area. This is through the CA, this program, this Green Corps program. Ben will be working on our BMP management. He'll be filling a void that we see. Our rules do have obligations, as you know, for the creation of BMPs on the landscape. We're trying to develop a toolkit, if you will. So the homeowners association or the private businesses that take these on will have some knowledge of what it exactly is that they'll be needing to do. Obviously, we have the legal requirements required on the property, but this would be a little bit more of a practical application of that, and then they can fully engage on their obligation. I don't see that Ben is with us, but we'll leave it at that. President Priner, I don't have any other updates.
So Nick, I have a question for you about that. Is this the one Marcus is supervising? The Green Corps member?
That's correct. We've placed the position, the volunteer Green Corps position, in the communication and outreach category. Marcus does have half of his time assigned there, and obviously Beth is involved as well.
And
Yeah.
was Marcus a Green Corps member?
I don't believe he was, no. He
You
was,
were, Lauren was. All right. Yes, it's an excellent program. Those AmeriCorps service program really is a great way to get smart young professionals into the field.
good to hear.
Any other questions for Nick? Okay, managers update. Manager Waller.
I already shared about the comments, so from the public, and I have no more.
Okay, thank you, Manager Wynan.
I'm looking forward to seeing you all face to face.
I agree.
Manager Bradley.
Nothing.
Manager Wagaman.
Nothing?
And I have nothing new, so let's have a motion to adjourn.
Move to adjourn.
I'll second that.
Motion to adjourn. It'll be a roll call. Manager Waller.
Yes.
Manager Wynan.
Yes.
Manager Bradley.
Yes.
Manager Wagaman.
Yes?
And Manager Priner, yes. So
See you guys.
moved, we're done.
All right. Thank you so much.
Thanks, everyone.
Yes, everybody enjoy the day.